Hi, good evening, everyone, and welcome back to part 2 of our mega revision of the Constitution. If you haven't seen part 1 of the video, just go to our page, CLAT Possible, and have a look at that. You'll also find a playlist of all of our last lap revisions. So, you have on the screen behind me some of the most important Constitution related topics. And yesterday, we took a look at quite a few of them. Now, as we go through, I will, of course, give you a very quick recap of what we did yesterday as well. So welcome back, get ready. I hope you have your pens and papers out. So we began with the 75 years of the Constitution having come into force on the 26th of January 1950. And I had told you this date was chosen due to the observance of the Purna Swaraj Day by the Indian National Congress on the 26th of January 1930. Next, we had taken a brief look at some of the important details about the Constituent Assembly, the chairpersons, what its functions were, the head of the drafting committee, the constitutional advisor, and so on and so forth. Okay, so please go to our first video to check out all of these details in case you haven't been able to take a look yet. Next, we had seen all of the important dates to do with the Constituent Assembly, right from its formation on 6th December 1946 to the adoption on 26th of November 1949, finally to the last session on 24th of Jan 1950, on which date the national song and the national anthem were also adopted and declared. I am flagging this again because 150 years of our national song, Vande Mataram, is also being observed. Okay. And finally, the Constitution comes into force on the 26th of Jan. And we saw yesterday that this day today is also observed as the International Day of Clean Energy. Okay. Next, we saw a little bit about what the country is called: a sovereign, socialist, secular, democratic republic. And then Article 1 describes our country as India, that is Bharat, shall be a union of states. Okay. Now, tomorrow is Constitution Day or Samvidhan Divas. So keep that in mind, right? So tomorrow is the date commemorating the adoption of the Constitution by the Constituent Assembly. Next, I had given you a brief idea of the structure of the Constitution. So I won't go into it again. Then let's go through this. This is something we had not been able to take a look at yesterday. Okay, so what I've done in the next few slides is framed the important amendments of the Constitution in the form of questions. So what I'll do is I'll get a little bit out of the way of the screen, so I'm able to talk to you while you are able to look at the questions. So what we'll do is quickly go through all of the questions. So let's begin. The first question we have here is: which amendment of the Constitution reduced the voting age from 21 to 18 by amending Article 326 of the Constitution? Okay, so think of this. This is important from the perspective of the Election Commission as well, which is relevant this year because it has also completed 75 years of its existence. And it's conducted the SIR as well as the vice presidential, Bihar and Delhi elections. So the answer to this is the 61st Amendment. Okay, so the 61st Amendment of the Constitution reduced the voting age from 21 to 18. Next, which schedule of the Constitution was inserted by the First Amendment Act? Okay, so now just think of it. We discussed yesterday that the original Constitution had how many schedules? 8 schedules. And so the First Amendment, which schedule would it have added? It added the 9th Amendment. What was put in the 9th Amendment? Basically a list of laws which would be immunized from judicial review. This was basically to enforce the vision of abolition of Jagirdari and Zamindar. Next, point 3, also relevant from the perspective of amendments, right? And this year a new amendment, the 130th Amendment Bill, was introduced. So the question is, the basic structure doctrine was propounded by the Supreme Court, in which case striking down part of Article 31C, which had been added by the 25th Amendment. So you all know that the case which established the basic structure doctrine was Kesav Nanda Bharati versus State of Kerala. Okay, this is called famously the basic structure case as well. And finally, which amendment added part 9B of the Constitution? Remember, the topic of cooperatives is very important this year because of the International Year of Cooperatives. This year, the National Cooperatives Policy of 2025, a cooperatives heritage platform by the International Cooperative Alliance. The first National Cooperative University has been established, which is the Tribhuvan Sehakari University at Anand, Gujarat. Okay, so from all of those points of view, the topic of cooperatives is exceedingly important. So remember, it was the 97th Amendment which added part 9B of the Constitution dealing with cooperatives. Okay, so I hope this is absolutely clear. Let's now go on to the next. Now the next we have, which words were added to the preamble by the Constitution 42nd Amendment Act. Okay, so this is something key. I think we discussed it yesterday as well. The answer to this will be socialist, secular, and integrity. Okay, so three words were added to the preamble by the 42nd Amendment, that is socialist, secular, and integrity. Next, we have question 6. Anti-defection provisions were added to the Constitution. In which schedule and by which amendment? Okay, so this you must always remember. What is anti-defection? These are provisions made to ensure that people don't change parties or vote against the instructions of their parties after being elected. So this, the answer is the 10th schedule and the 52nd amendment. Okay, so anti-defection provisions were added by the 52nd amendment into the 10th schedule of the Constitution. Next, which part of the Constitution was added on the recommendation of the Sardar Swaran Singh Committee? Right? So just remember, Sardar Swaran Singh was one of the ministers under Prime Minister Indira Gandhi. And what is that famous massive amendment which took place? The 42nd Amendment. It's also popularly called the mini constitution. Right? Now, but the main recommendations of the Sardar Swaran Singh Committee were relating to Part 4A. What is Part 4A? It is the part which deals with fundamental duties. Okay. Finally, which of the following is incorrect about the latest amendment of the Constitution? Okay. So what is the latest amendment? It is the 106th Amendment of the Constitution, which added provisions for 33% reservation for women in parliament as well as state legislatures. Right? This is also called the Nari Shakti Vandan Adhiniyam or the 106th Constitution Amendment. So the question, always remember, the question is which of these is incorrect? So of course option A is true. B says it provides for reservation of seats for women. This is also true. C says it provides for 1/3 reservation of seats for women. This is also true. Finally, it says it only provides reservation for women in parliament. This is the one which is false. Okay, so option D is the one which is incorrect in this particular question. Okay, so I hope this is clear. Let's now move on to the next. Let's see. The Constitution 69th Amendment provided for a Vidhan Sabha for which union territory? Okay, so the 69th Amendment provided for a Vidhan Sabha for the union territory of Delhi or Pondicherry. Tell me. Now you have to answer which of these two is the correct answer. I'll wait for a moment till you are able to give me some responses in the chat. Yes, I hope some of you have given answers in the chat. So the answer to question 9, the Constitution 69th Amendment Act provided for a Vidhan Sabha for the Union Territory of Delhi. Okay, so those of you who got it right, that's excellent. Let's now move to question 10, which asks which amendment of the Constitution turned the right to property from a fundamental to a constitutional right. Okay, so the answer to this is the 44th Amendment. Okay, the right to property was removed from Article 19(1)(f) and shifted into Article 300 capital A. Okay, so it went to 300 capital A from 19(1)(f). Okay, next, which of the following amendments is not related to the delimitation process? So pay attention, it asks not related, and the answer here is none of the above. Okay, all three, the 42nd, 84th, and 87th amendments are all linked to the delimitation process. Now, why is delimitation important this year? Because you have to link it to the announcement of the next census. Okay, census is a vitally important topic, and the next census has been announced, which will officially be called the census of 2027. But some parts will also take place in 2026. So please do cover this topic. This is absolutely important and relevant. You should know who is the census commissioner as well. And finally, delimitation can only occur after the next census. Okay, so please link it to that. And we also saw the 106th amendment for women's reservation. That can only be implemented once the delimitation is done. Delimitation can only be done after the next census is done, and the next census is in 2027. Okay, finally, question 12 asks the Constitution's 7th amendment created which of the following category of territorial units? So the answer to this is union territories. Okay, so before this, at the commencement of the Constitution, there was no concept of union territories, right? There were Part A states, Part B states, Part C states. But in the 7th amendment, the concept of union territories was created for the first time. Let's now move on to the next. The next question asks, the Constitution 12th amendment incorporated which of the following territories into India? Okay, so the 12th amendment, think of it, the 12th amendment relates to Goa, Daman and Diu. Okay, these were incorporated from the Portuguese by the 12th Amendment Act. Next, which amendment was the first to add a language to the 8th schedule? So remember, the 8th schedule of the Constitution is the one which lists Indian languages. We call these either official languages or even scheduled languages. Okay, so remember, we have discussed there is no national language in the country. So originally the 8th schedule had 14 languages. Now it has 22. Okay, now the very first language to be added after the 14th was Sindhi by the 21st amendment. Okay, let's now move on to the next. Which amendment of the Constitution made it compulsory for the president to give his assent to bills seeking to amend the Constitution? Okay, so this is an interesting one. Why is this relevant? 50 years of the emergency, right? So link it with that. The emergency, you can also take it to revise the flashpoint between the legislature and the judiciary, right? In terms of the process of amending the Constitution. Related to this, we also saw Kesavananda Bharati. Okay, so I want you to find the answer to question number 15. Okay, next, let's come to question 16. The Constitution 26th Amendment Act abolished which of the following? Okay, so the answer, of course, is privy purses. Okay, privy purses were basically annual pensions given to princely state rulers who had given up their kingdoms and merged them with India. Okay, so the 26th amendment abolished those. Okay, remember forced labor is already abolished by Article 23. Titles are already abolished by Article 18. Okay, let's now go on to the next. Now we won't go through all of these questions. Okay, we won't go through all of these questions. Let's directly come to question 18. So question 18 asks, which decision of the Supreme Court invalidated the amendments made to Article 368 by the Constitution 42nd Amendment Act to put these amendments beyond the scope of judicial review? So the answer to this will be Minerva Mills versus Union of India. Okay. Next, which amendment of the Constitution added the parts on fundamental duties and tribunals? So this is again the mini constitution, the 42nd amendment. Okay. Let's now come to question 20. Which of the following is incorrect relating to the National Commission for Scheduled Castes, Scheduled Tribes, and Backward Classes in the Indian Constitution? Okay. So all of these statements are true, which means none of these is incorrect. Okay. The 65th Amendment created a joint National Commission for Scheduled Castes and Scheduled Tribes. The 89th Amendment created separate National Commission for Scheduled Castes and a separate National Commission for Scheduled Tribes. And finally, the 102nd Amendment gave a constitutional status to the National Commission on Backward Classes. Okay, I think this is the last set on the important amendments. So question 21 asks, Konkuni, Manipuri, Nepali were added to the 8th schedule by which amendment? The answer to this will be 71st. Next, which amendments gave constitutional status to panchayats and municipalities? Of course, the answer is 73rd and 74th. The 73rd amendment relates to panchayats and the 74th amendment relates to municipalities. Okay. Next, let's come to question 23. This is important, right? Because of 5 years of the national education policy. So the Constitution 86th Amendment added which of these rights? The answer is, of course, the right to education. Remember, this made 3 amendments, one to part 3 by adding Article 21A. Another amendment was made to part 4 by amending Article 45. And an additional duty was added by amending Article 51A in part 4A. Next, we have the 91st Amendment, which restricted the total size of the Council of Ministers and said it would be restricted to 15% of the lower house. And finally, which of these is wrongly matched? So 103rd Amendment added economically weaker sections reservation. This is true. 101st Amendment added GST. This is true. 104th Amendment did not add NJAC. It was the 99th Amendment which added the National Judicial Appointments Commission, which was later struck down by the 4th judge's case. Finally, the 92nd Amendment added 4 languages. This is true. What are those? Bodo, Dogri, Maithili, and Santhali. So I hope that's been a good and detailed revision of the important amendments. Let's now move on to the next. We had also seen yesterday the latest proposed 130th Amendment Bill. Of course, it's too late for your CLAT, but just last week, the government is also planning a new Constitution Amendment Bill, basically to change the constitutional arrangements relating to the Union Territory of Chandigarh. Okay. Next, we saw the Vice President. Of course, Mr. Dhankar resigned and Mr. C.P. Radhakrishnan was elected as the 15th Vice President. We saw the details, the important records, right? Who conducts the VP election? It's the Election Commission. And all the MPs of Lok Sabha and Rajya Sabha are part of the Electoral College. Let's now move on to the next. Next, we saw the 50 years of the emergency. right? So this is the national emergency imposed on grounds of internal disturbance, because of which the government is also celebrating Samvidhan Hatya Divas. So what is this day? 25th of June 1975, when the emergency was proclaimed. That has been observed as Samvidhan Hatya Divas by the government. Remember, it was proclaimed by Fakhruddin Ali Ahmad on advice of Indira Gandhi, and ultimately the proclamation revoking the emergency was issued by acting President B.D. Jatti on 21st of March 1977. Okay, so we discussed all of these in detail yesterday. Let's now move on to the next. Finally, yesterday, the last topic we were looking at was 75 years of the creation of the Supreme Court, right? So we saw a bit of background. The precursor of the Supreme Court was the Federal Court. We saw the important records from the Federal Court and of the Chief Justices of India. As you might have seen, Justice Suryakant has now taken office as the 53rd Chief Justice. But also this year, the 52nd Chief Justice took office. That was Justice Bhushan Ramakrishna Gabai, the second Dalit and the first Buddhist Chief Justice of India. Okay, I had given you a brief about the number of judges, the appointment process as well. And the last slide I believe we were taking a look at was this. The three most, or at least two most important, and then the book is kind of the third one I've mentioned on this slide. So number one, all of the processes about Justice Yashwant Verma. Now I had told you in-house procedure is separate and removal process is separate. Okay, so please don't confuse the two. In-house procedure's job is not to remove a judge. In fact, no person other than Parliament has the power to impeach a judge or remove a judge. Okay, the in-house procedure simply happens within the judiciary to ascertain the truth or falsity of the allegation. Okay, so in his case, an in-house procedure was conducted with 3 judges doing the inquiry. Just remember it as SSS, GS Sandhavalia, Sheel Nagu, and Anu Shivaram. At the end of which the report found that the allegations were true and serious enough to merit removal. Now, since the judiciary cannot remove a judge, the Chief Justice of India did all that he was allowed to do. He wrote a letter to the President and the Prime Minister attaching the report and saying this is what we have found. Now, separately, the removal process has begun as provided by Article 124, Clause 4, read with the relevant article for the High Courts and the Judges Inquiry Act of 1968. Under this, the motion was admitted by the Speaker, Mr. Om Birla, and a committee was formed. We can say AMA. Arvind Kumar, Manindra Mohan Srivastav, and B. Vasudev Acharya. Okay, so please remember these two committees. The in-house committee, Sandhavalia, Sheel Nagu, and Anu Shivaraman, SSS, under Judges Inquiry Act, read with the Constitution, AMA, Arvind Kumar, Manindra Mohan Srivastav, and B. Vasudev Acharya. We've already done the 52nd and 53rd Chief Justice of India. Okay, let's now move on to the next. Now we've seen 75 years since the Constitution, 75 years of the Supreme Court, and 75 years of the Election Commission of India. Let me move out of the way a little bit, just so you can see the whole screen. Now, Election Commission is always important, but this year it's been at the center of controversy regarding the Special Intensive Revision or the SIR. Other than that, it has also conducted the Delhi election, the Bihar election, as well as the vice presidential election. Not only that, the latest Chief Election Commissioner was also appointed during the year. Other than that, the National Voters' Day was of course observed. at the beginning of last year. Okay, so please keep all of these things in mind. Okay, now let's cover this quickly. So in the slide about the various parts, we've already seen that elections are covered by part 15 of the Constitution. Okay, part 15, the most important article is Article 324, which creates the Election Commission, comprising of the Chief Election Commissioner and other election commissioners. Right now, the number is specified at 2. So, one Chief Election Commissioner and 2 other election commissioners. Okay. Now, please remember, what has the ECI been charged to do? They have been given superintendent's direction and control over preparation of electoral rolls and conduct of elections. For what all? For the president, the vice president, Lok Sabha and Rajya Sabha, Vidhan Sabha and Vidhan Parishad. Okay. However, remember, the Election Commission does not conduct, the Election Commission of India does not conduct panchayat and municipality elections. That is the job of the state election commissions. Okay. So please be clear on that. Now, who appoints the CEC and other election commissioners? They are, of course, appointed by the president, though there is some controversy about the method of appointment. We are going to take a look at that in this point. Okay. What about process of removal? The Constitution says that the CEC, remember, the Chief Election Commissioner can only be removed in the same way as a judge of the Supreme Court. Okay. So the impeachment or removal process prescribed under Article 124, Clause 4 for judges of Supreme Court also applies to judges of High Court, also applies to the Chief Election Commissioner, and also applies to the Comptroller and Auditor General of India. Okay. Now coming to the matter of appointment. Okay. Now for the longest time, the president would simply appoint the Chief Election Commissioner and other election commissioners on the advice of the Union government. However, a few years ago, a case was heard in the Supreme Court called Anup Baranwal versus Union of India. Okay, Anup Baranwal versus Union of India. Now, in Anup Baranwal, the court said free and fair elections, an independent election commission. This is part of the basic structure of the Constitution. It must be ensured. And the way to do it is that there should not be dominance of the executive in this process. Okay, I hope that is clear. Accordingly, it said, since no procedure was set out, the court would give directions that the president would appoint the Chief Election Commissioner and the other election commissioners on the recommendation of a committee. Who would be in this committee? The members of the committee would be Prime Minister, Leader of Opposition in the Lok Sabha, as well as the Chief Justice of India. So this was the structure directed by the Supreme Court in Anup Baranwal versus Union of India. Now, what happened is, after this, the Parliament enacted the CEC and Other Election Commissioners Act of 2023. And through this act, they changed the composition of the selection committee as ordered by the Supreme Court. So what the Supreme Court had said was that the committee would be PM, Leader of Opposition and Chief Justice of India. What the Parliament enacted through this law was PM, Leader of Opposition in the Lok Sabha, and any one Union Cabinet Minister nominated by the PM. So you can see it again led to the kind of executive dominance that was deprecated by the Supreme Court in Anup Baran. Anyway, this act is now under challenge in the Supreme Court, saying that it is unconstitutional. Okay, so I hope that is clear. Right now, even the latest Chief Election Commissioner has been appointed under the process of this particular act. Okay, now Let's quickly do the records. Who was the first Chief Election Commissioner? This was Mr. Sukumar Sen. Okay, this was Mr. Sukumar Sen. Who is the current one? His name is Mr. Gyanesh Kumar. He has been the subject of much controversy throughout this year. And who was the first female Chief Election Commissioner? Her name was V.S. Ramadev. Okay, so these are three important figures whose names you need to know. I'll give you a small bit of homework. You have to find out the names of the two other election commissioners who are currently part of the Election Commission of India. Okay. Finally, the last couple of things. The National Voters' Day was observed on the 25th of January because this is the date on which the Election Commission's offices were established in the year 1950. Hence, 75 years of the Election Commission. Their office is called Nirvachan Sadan, or voting house. Okay, so that is that. I've mentioned the full forms of EVM and VVPAT. Please be sure you know what they are. This can exactly be the kind of random question you get in a passage about any news item related to this topic. You have seen these elections conducted in 2025. So who became the CM of Delhi after this election? It was Rekha Gupta. Who became the CM of Bihar? Mr. Nitish Kumar, once again, I think sworn in possibly for the 10th time. The vice presidential election was conducted. Who was sworn in? Mr. C.P. Radhakrishnan. And of course, the huge issue this year was the SIR, which was conducted for the first time in the state of Bihar. What is that? The Special Intensive Revision. Now, what is important to note, people have challenged this process for several reasons, saying number one, neither the act governing the ECI, nor the constitution, nor the rules, nor any regulations ever mention this word. They talk about special revisions, but they don't talk about special intensive revision. This is a minor point. The larger point is, it is argued that SIR reverses the burden, because what this SIR does is asks each and every citizen to submit an application to make sure whether they are citizens or not. Whereas Supreme Court judgments across Indian history have held that once a person is part of the voter roll, if the Election Commission believes that they are not a citizen or they are not an eligible voter, the duty is on the Election Commission to conduct a process and remove the person. The duty to prove is on the Election Commission. What SIR does is reverse this burden and puts all the onus on the citizen, saying if you do not fill the form, we will assume there is something wrong and not add you to the list. Okay, so there are significant reasons for opposing this. Remember, the first SIR has happened in the state of Bihar, and it led to a deletion of a vast number of voters there as well. After Bihar, the Election Commission has announced that the special intensive revision is going to take place nationwide. Okay, please remember, you have to know the exact full form, which is the special intensive revision. Okay, let's now move on to the next. Now, the Finance Commission came in the news several times throughout this year. Now, first remember, what is the job of a Finance Commission? The job of the Finance Commission is to recommend how tax revenues will be divided between the union and the state. So it's an important body from the perspective of federalism, because it recommends how tax revenues will be divided. Now, Article 280 creates this body, making, of course, this a constitutional body. Okay, just like the Election Commission. Let's quickly do the first and current chair. So the first was Mr. K.C. Neogi. Okay, Mr. K.C. Neogi was the first chairperson, whereas the current chairperson is Dr. Arvind Panagaria. Okay, he is currently heading the 16th Finance Commission, whose job it is to give recommendations for division of tax revenues in the time period 2026-27 to 2030-31. Okay, so that is the term for which the Finance Commission has to give its recommendations. We've already done the chair. Now, Finance Commission came in the news for two reasons. Earlier in the year, it was announced that the government had granted a short extension to enable them to complete their report. And finally, I believe just this beginning of this month or end of last month, it was reported that the Finance Commission has submitted its report. Okay, so please keep this body in mind. It's not one we easily or usually discuss, but please keep this one in mind. Okay, now let me now bring you to the last slide. Okay, now it has quite a few important things. We are going to take them up one by one. Now, the first one here is that the Attorney General, okay, the Attorney General, which office is created by Article 76 of the Constitution. Who is he? He is the top law officer of the Union government, right? His job is to argue cases and provide legal advice on behalf of the Union government, its agencies and instrumentalities. So it's a constitutional office. He has certain special powers. He has the right to be heard in any court or country, in any court in the country. And secondly, he has the right to attend and speak in any session of parliament. Okay, though he cannot, of course, vote. Okay. Now, who was the first Attorney General? This is a very significant figure in the legal world. His name is MC Setalvad. Okay, that stands for Motilal Chimanlal Setalvad. Okay, he was not only the first Attorney General, he was also the first chair of the Bar Council of India, and he was also the first chair of the Law Commission of India after independence. Okay, so Mr. MC Setalvad is a very significant figure, having been the inaugural holder or first chair of the Bar Council of India, the Law Commission of India, as well as the first Attorney General. Okay, so which article creates this office? Article 76. Who was the first? The first was Mr. MC Setalvad, who is the current Attorney General, whose term was extended. Okay, he had been appointed for 3 years and the term would have ended this year, but his term was further extended. So his name is Mr. R. Venkata Ramani. Okay, this is R. Venkata Ramani, senior advocate. Okay, so Mr. R. Venkata Ramani is the current Attorney General. The news was that his term has been extended. The last thing I want to mention is this other office, which is the Solicitor General. The role of the Solicitor General is also to represent the Union. However, this office is not a constitutional office or a statutory office. It is simply created by an order of the government. Right now, possibly the most famous and powerful lawyer in the country is the Solicitor General, even though he is number 2 below the Attorney General technically. His name is Tushar Mehta. Okay, and the first Solicitor General was Mr. C.K. Daftari. Okay, I hope this is absolutely clear. Next, let's come to 100 years of UPSC. I do not want to dwell on this too much because this is a topic we have covered in one of our other last lab videos. But simply to give you a recap, so it is part 14 of the Constitution, which deals with the services, and Article 315 creates the Union Public Service Commission. Originally, this had been created as the Public Service Commission on 1st of October 1926 on the recommendations of the Lee Commission. Then, after the Government of India Act 1935, it came to be known as the Federal Public Service Commission. And finally, under Article 315 of the Constitution, it came to be known as the Union Public Service Commission. So who was its first chair? It was Mr. Ross Barker. Who was the first Indian chair? Mr. H.K. Kriplani. The first female chair, Rose Million Bathew. And the current chair is Mr. Ajay Kumar. Now, UPSC is in the news for two reasons. Number one, Mr. Ajay Kumar's appointment, the current UPSC chair. And second, the beginning of the 100-year celebration. So the 100 years of UPSC are being celebrated from the 1st of October 2025 to the 1st of October 2026. Okay, so I hope this is absolutely clear. If you want any further details, please refer to our earlier last lap revision video. They're all available in one playlist on our YouTube channel, CLAT Awesome. Now, the next topic which we have here is a significant one. This is the Tamil Nadu governor case, right? So who is this governor who is at the center of this controversy? This is Mr. Ravi. Okay. Now, he has had a very contentious relationship with the Chief Minister of the state of Tamil Nadu. Now, at the core of this dispute is Article 200 of the Constitution. Okay. So, Article 200 of the Constitution deals with the possible actions that a governor can take. Now, so in this case, there were issues like he would keep bills pending for too long. Once having kept them pending for a long while, he would send them back to the legislature or refer them for consideration of the president. So anyway, the state of Tamil Nadu had filed a case in the Supreme Court asking that all of this be put an end to and asking for an authoritative ruling. So this resulted in a case being decided by the Supreme Court by a bench of two judges, I believe, which was called the State of Tamil Nadu versus the Governor of Tamil Nadu. So that's the name of this case. Let me just put it on the screen for you. This is the State of Tamil Nadu versus the Governor of Tamil Nadu. Okay, so this case got decided by the Supreme Court around mid-year, I think around May or April. And what is it that the Supreme Court held? Okay, the Supreme Court held that when a governor receives a bill which has been passed by the state legislature, okay, he only has a very limited number of actions that he can take, right? So what could those options be? People would argue that one option would be to say yes, meaning assent. One option being to withhold assent or say no. One option to refer it back to the legislature for reconsideration. And another option would be to reserve it for the consideration of the president. Right? Another thing could just be a pocket veto, not decide altogether, and to simply keep the bill in his or her pocket. Okay. So I hope this is absolutely clear. Now, what is important to note here? What I just said is simply what was the traditional understanding. Okay, that was the traditional understanding. What the court held in this case, in the state of Tamil Nadu versus the governor of Tamil Nadu, the court said, of course, one option is to assent to the bill, say yes. Then the court said another option is to withhold assent, that is to say no. But the court said this is coupled with sending the bill back to the legislature for their reconsideration. Okay, so basically the court said the governor does not have a simple option of withholding assent or saying no. Rather, if the governor wished to withhold assent, he should say he is withholding assent and simultaneously send the bill back for reconsideration by the legislature. Further, the court said, yes, there was an option of sending the bill for the consideration of the president. And lastly, the court held, remember, we are still talking about the original. Lastly, the court held that the concept of a pocket veto was alien to the constitution. Okay. Further, what became a source of much controversy later was that the Supreme Court ordered that certain time limits should be observed for how long a governor can take to take his decision, and then once it goes to the president, how long the president can take to make his or her decision. Okay, and finally, in probably one of the most controversial aspects of this decision, the Supreme Court gave deemed assent on behalf of the governor under Article 142 of the Constitution, using their power to do complete justice. Now, this created a lot of issues. Okay, it was an admirable judgment, an innovative one certainly, but an admirable judgment, seeking to curb the untrammeled exercise of power by governors as well as the president, and trying to uphold the federal spirit of the constitution. Okay, so with that in mind, okay, so this is ultimately the holding of the state of Tamil Nadu versus the governor of Tamil Nadu. The executive, of course, was not very happy with this judgment. So a very rarely used power was utilized. That is the power of presidential reference, which is also sometimes called the advisory jurisdiction of the Supreme Court. Okay, so first let's have a brief look at this. So the advisory jurisdiction of the Supreme Court flows from Article 143 of the Constitution. Okay, please be advised of that. Under this article, the president has the power to refer questions of law or fact to the Supreme Court and asking them for their opinion on the same. However, it is not compulsory for the Supreme Court to answer, and they can respectfully decline. So after the decision in the state of Tamil Nadu versus the governor of Tamil Nadu, the president made a reference under Article 143 to the Supreme Court, seeking their response on a few questions. Now, this itself is highly controversial because, in effect, it is a way to sort of overturn or muddy the waters of the decision already given in state of Tamil Nadu versus governor of Tamil Nadu. What I'll do is, since this is relatively recent, what I did is I took a printout of the important conclusions reached by the Supreme Court in the presidential reference. So let's discuss them. Now, in this reference, the court answered it. Okay, they answered almost all of the questions posed and said that the governor has three constitutional options before him under Article 200. Okay, so when it comes to Article 200 and a bill is presented to the governor, what are the three options according to the Supreme Court? Number one, to assent, meaning to say yes. Number two, to reserve the bill for the consideration of the president, or to withhold assent and return the bill to the legislature with comment. Okay, so they said there are only three alternatives: either say yes, meaning give assent, or say no, that is withhold assent, while sending the bill back to the legislature, or number three, reserve the bill for the consideration of the president. So these are the only three options available to a governor. Okay, there is no dispute or no disagreement between the Tamil Nadu governor case or the presidential reference opinion given by the Supreme Court on this matter. Okay, moving on. Then the court said, so please be advised about this. Only three possible options for the governor: either give assent, or withhold assent and send it back to the legislature, or reserve it for the consideration of the president. These are the three options available. Okay. Now, the court clarified that any of these could be done by the governor in his own discretion, right? And in this, he would not be bound by the aid and advice of the Council of Ministers. Okay. Further, the court said that the discharge of functions of the governor in choosing these options is not justiciable. So this is different from what the earlier case had held. And the court in its opinion said that it is not justiciable, but only if there is a very long delay in deciding, meaning essentially in cases of a pocket veto, the court could issue an order to the governor to decide. And of course, the court could not tell the governor how to decide. Okay. So I hope this is absolutely clear. Okay. Next, the court said that it would not be right for the Supreme Court to issue guidelines in the form of timelines to be followed by the president or the governor. So that is what the court said in its advisory jurisdiction, right? In its opinion or report given to the president. Okay. So on this point, of course, there's a big disagreement between the earlier case and the new presidential reference. Okay. So importantly, the big disagreement was on the setting of timelines, and in the advisory jurisdiction, the court with 5 judges gave an opinion that the court had no power to prescribe timelines. However, if the governor took too long, effectively amounting to a pocket veto, then the court could order the governor to decide. Okay. So I hope this is absolutely clear. Okay. Next, there were a bunch of other things that were laid down in this advisory opinion. However, this is what was most important. Further, in the advisory jurisdiction, the court also answered that using the power to do complete justice, or under Article 142, the court would not have the power, my apologies, that under 142, the court would not have the power to give deemed assent, as had been done in the case of State of Tamil Nadu versus Governor of Tamil Nadu. Okay, I hope this is absolutely clear. If you have any questions on this topic, you can, of course, post them down as comments, and I will answer them within the next 24 hours. Okay, so I hope this is absolutely clear. Okay, so this case is very important this year from the perspective of both legal reasoning as well as GK. Keep in mind this case, the important interpretation on what all the governor can do, what was controversial and the source of disagreement even between this judgment and the advisory opinion of the court, was on prescription of timelines and on giving deemed assent. So the original judgment thought that timelines could be prescribed and deemed assent could be given, but the advisory opinion disagreed. Okay, so I hope that has served as a good summary for you. Next, I've mentioned here the case of Ladakh, which is now a union territory, and its demand for statehood and 6th schedule status. Okay, so I just don't want to get into too much of it, but remember Mr. Sonam Wangchuk, a prominent activist in his own right and a very celebrated figure in the community of Ladakh, was arrested, rather I should say was preventively detained under the National Security Act, which is the union's main law for preventive detention. I personally think it's probably time to do away with the whole idea of preventive detention, meaning detaining people who have not committed crimes. But in this case, due to the protests in Ladakh, the union government, through the union territory of Ladakh government, has basically put Mr. Wangchuk on preventive detention. So what I wanted to cover for you is the point about Ladakh demanding statehood and 6th schedule status. Okay. Now remember, in our last video, we had seen the basic structure of government in the constitution, and we saw part 10, which deals with scheduled and tribal areas. Okay. So that relates to the 5th schedule and the 6th schedule. Okay, so please be clear about that. In this case, the citizens of Ladakh or the people of Ladakh have been demanding 6 schedule status, which right now only it has been given to Assam, Meghalaya, Tripura, and Mizoram. So Ladakh wants to be added to this list apart from being made a separate state. Okay, in 6 scheduled states, there is a concept of autonomous district councils and autonomous regional council. Okay, whereas in the 5th schedule, governance happens through the governor and tribal advisory councils. Okay, so remember, 6th schedule only applies to 4 states which are listed here. 5th schedule can apply to any of the other states except these 4. Right now, there are 10 states which have 5th schedule status. The demand of Ladakh was for 6th schedule status. Okay. The last 2 things I have mentioned here, which touch upon various other things in the news. One is a new committee was established by the state of Tamil Nadu called the Committee on Union-State Relations, which is chaired by retired judge of the Supreme Court, Justice Kurian Joseph. Okay, this has a rich history. The very first Committee on Union-State Relations after independence, after the Constitution, was also created by the state of Tamil Nadu, and it was called the Rajamannar Commission. Okay. After that, of course, 2 separate commissions were established by the union government over time, the Sarkaria Commission and the Punchi Commission. Now, finally, in 2025, so this is absolutely current, in 2025, the state of Tamil Nadu has made a committee on union-state relations, chaired by Justice Kurian Joseph, to submit a report regarding, of course, union-state relations. As you know, you've seen in other sessions with ma'am as well, there are controversies between the state of Tamil Nadu and the union government relating to the national education policy, the 3-language formula, and so on and so on. The last aspect for today, you all know that GST reforms have taken place this year, what is being called GST 2.0. It is a rate rationalization with a separate rate for luxury or sin goods. Everything else has been consolidated into fewer number of rates. So all I wanted to do was to flag for you its constitutional aspects. So the goods and services tax regime was created by the 101st Amendment to the Constitution, and they also created a body called the GST Council, which is created by Article 279 capital A, which is always chaired ex officio by the Finance Minister of India. Okay, so that's all I wanted to cover. We are back on the original slide. So we've done a lot. 100 years of UPSC, the 130th Amendment Bill from this year, the resignation and then the election of the new Vice President, Ladakh and the demand for 6th schedule, the 75 years of the Constitution, 75 years of the Election Commission, 75 years of the Supreme Court, 50 years of the emergency Samvidhan Divas and Samvidhan Hatya Divas, the Tamil Nadu governor case, and the use of the Supreme Court's advisory jurisdiction under Article 143. Then we also saw the latest VP, the 52nd and 53rd Chief Justices of India, constitutional aspects of GST, and finally, the big news this year relating to Justice Verma's in-house procedure as well as his removal process. So I hope these 2 videos, part 1 and part 2, have been useful for you, that they've helped you sort of put it all together, right? It's almost a jigsaw puzzle of different news items related to the Constitution. So I hope it's been useful for you putting these together. I certainly have had a good time bringing these to you. So thank you all for tuning in. It's always nice to see you all. Stay tuned. We have very soon, actually in the next 10 minutes, our session on the defense news of 2025. So stay tuned. We soon have sessions on the environment as well as the Israel-Palestine issue as well. So subscribe to our channel, keep coming back, and I look forward to engaging with you again. Thank you and bye-bye.